Dear clients and business partners, today we would like to remind you about precautionary measures which you should consider before entering into an agreement. In particular, you should never forget to keep in mind that different corporate restrictions may influence actions of your counterparties. Before signing of the transaction documents, your corporate lawyer should check if such restrictions exist and what do they provide for, because this may significantly influence the future deal. So, where such corporate limitations follow from? Firstly, they follow from the legislation, and these are widely known provisions about major transactions and interested party transactions. But secondly, which is the most important, they follow from four kinds of corporate documents. They obviously include the charter of the counterparty, its internal regulations, for example, regulation regarding general meeting of participants or the board of directors, then the shareholders' agreement, and finally, so-called normative corporate resolutions. The example of such a corporate resolution may be the one of the general meeting regarding election of the board of directors. It's interesting that now neither the court practice nor the legislation obliges us to analyze these four kinds of corporate documents. But the same court practice, in some cases, allows recognizing of the transactions invalid due to violation of such corporate restrictions. This is why, in the course of due diligence of a counterparty prior to concluding an agreement, all four kinds of corporate documents are always carefully checked. You should also remember that now Russian law provides for an option of several directors for one company. This means that in such cases, the particular powers of each director follow from the internal documents of the company and are not mentioned in the State Register of Companies. This is why, in this case, it won't be enough to look in the State Register to understand if the concrete director has the powers to conclude a certain deal. Many businessmen and even lawyers also forget to check if their counterparty is in the course of reorganization. And this is important because the corporate restrictions may also follow from the documents of the company regulating its reorganization. To summarize the above mentioned, we can recommend you to check if you have contacted your corporate lawyer before signing of the transaction documents. This will help to avoid court proceedings regarding challenging of transactions in the future and will save your money, time and effort. Our corporate team will be very glad to provide you with the information about which particular documents should you ask from your counterparties and what should you search for in such documents to secure yourself. So please feel free to reach out. Thank you.